Good morning. This video is intended for my criminology students. However, it is also very beneficial to those working in the public service and those who are working in the private companies. And later on in this law, we will be discussing the coverage and it is not a substitute for any learnings and review classes you have in your course. This is just only a sort of discussion when it comes to the salient features of RA number 7877 or the Anti-Sexual Harassment Act of 1995. And every law, there is a declaration of policy. And Section 2 provides that the state shall value the dignity of every individual, enhance the development of its human resources, guarantee full respect for human rights, and uphold the dignity of workers, employees, applicants for employment, students, or those undergoing training, instruction, or education. Towards this end, all forms of sexual harassment in the employment, education, or training environment are hereby declared unlawful. Section 3, work, education, or training-related sexual harassment defined. Ano nga ba yung sexual harassment as defined by this law? Work, education, or training-related sexual harassment is committed, you have to take note, by an employee, manager, supervisor, agent of the employer, teacher, instructor, professor, coach, trainer, or any other person who having authority, influence, or moral ascendancy over another in a work or training or education environment. So we have to take note of the word having authority and influence. This is the two most important words in this section. Demands, requests, or otherwise requires any sexual favor from the other, regardless of whether the demand, requests, or requirement for submission is accepted by the object of the said act. These are the acts that will constitute sexual harassment, and these include someone who is cracking sexual jokes and comments around or to you, questioning you about your sex life, and insulting you with sexual comments, behavior on a phone call that makes you feel uncomfortable, indecently exposing themselves to you, and sexually assaulting you. Though these are the enumerations, but this is not exclusive. There can be another acts of sexual harassment. No. In a work-related or employment environment, sexual harassment is committed when first the sexual favor is made as a condition in hiring or in the employment, re-employment, or continued employment of the said individual, or in granting the said individual favorable compensation, terms, conditions, promotions, or privileges. We have to take note that this is regardless you're working in a private company or you're working in a public company or government, uh, so long that these acts are committed by a certain individual which has the influence. Example of this, yung mga managers, mga employers, no, na mag-hire ng mga employees in a certain company, or principals na mag-hire ng mga teachers in a certain institution. Or the refusal, kung halimbawa merong refusal to grant sexual favor results, if it will results in limiting, if you refuse to all of these sexual favors, and as a result, there will be limiting and segregating or classifying the employee, which in a way would discriminate, deprive, or diminish the employment opportunities, or otherwise adversely affect the said employee. So if you refuse to do the sexual favors, and then as a result you will be deprived of attending seminars, uh, you will not sent to the seminars, no, you will not be sent to training, or if it will deprive of your promotion because you refuse to do the sexual favors. It could also be a an act of a sexual harassment in the workplace. We have here examples of the acts. We have to identify whether it constitutes sexual harassment or not. First example, teacher Uga will only get an outstanding rating from master teacher who won if he will kiss him. This is very obvious that there is a sexual harassment, act of sexual harassment, because there is a sexual advances, an exchange of the favor. There is an exchange of favor to get an outstanding rating only if master teacher who won will get a kiss from teacher Uga. We have here another example. Student Uga get the passing grade of the subject after dating teacher 1. This is another example of sexual harassment. Though dating is not bad per se, but since there is a influence over the student, the teacher is under the obligation to take care of all of his students. No, but in this case, there is an exchange of the favor. So in exchange of the favor, you will get a passing grade. I mean, the student Uga will get the passing grade if he will date teacher 1. Next example, teacher Ugahip is dating with student Uga. In this example, there is no condition, no, when you are going to date with teacher Ugahip. If student Uga will date teacher Ugahip, there is no condition. Though it will not constitute sexual harassment, but it is a clear violation of the Code of Ethics for Professional Teachers, particularly in Article 8, Section 7, which provides that in a situation where mutual attraction and subsequent love develop between teacher and learner, the teacher shall exercise utmost professional discretion to avoid scandal, gossip, and preferential treatment of the learner. And we have to take note that teachers are duly licensed professionals who possess dignity and reputation with high moral values as well as technical and professional competence in the practice of their noble profession. And they strictly adhere to observe and practice this set of ethical and moral principles, standards, and values. Another example is master teacher who won got his promotion after sexual engagement with principal Olga. We have to take note the definition of sexual harassment, that these are the behavior characterized by the making of unwelcome and inappropriate sexual remarks or physical advances in a workplace or other professional or social institution. In this example, there is a sexual engagement with Principal Olga after master teacher one got his promotion. And we have to take note that there are forms of sexual harassment. Number one, physical, malicious touching, overt sexual advances, gestures with lewd insinuation. Second, verbal, such as but not limited to requests or demands for sexual favors and lurid remarks. Three, use of objects, pictures, or graphics, letters, or written notes with sexual underpinnings. And four, other forms of analogous to the foregoing. And since there is a sexual engagement, it will not form part of the forms, or it is not within the enumeration of the forms of sexual harassment. It could be penalized by other laws, such as the Code of Ethics for professional teachers, and both of them, no, is violating the Code of Ethics for professional teachers. But this is a case-to-case basis. But since there is a condition on the sexual engagement, I mean, there is a condition of his promotion after they will have a sexual engagement. Or it could be a violation of RA 6713. Another example is Master Teacher 1 single is dating with Principal Olga, and that is they are both single, so there is no violation when it comes to their relationship because both of them are single. And since there is no condition to the acts of Master Juan and Principal Olga in this example. And number two, the above acts would impair the employee's rights or privileges under existing labor laws. Or the above acts, yung mga nasabi kanina na mga acts, would result in an intimidating, hostile, or offensive environment for the employee. So if that would constitute of to impair the privileges and to intimidate the employee, then it will constitute a sexual harassment. Letter B, in an education or training environment, sexual harassment is committed. Number one, against who is under the care, custody, or supervision of the offender. One of the examples of this are the teachers, the trainers, or the coaches. No? Number two, against one whose education, training, apprenticeship, or tutorship is entrusted to the offender. Like what I've said na yung mga trainers and mga coaches natin in the educational institution. Number three, when the sexual favor is made a condition to giving a passing grade, yung example natin kanina, or the granting of honors and scholarships, or the payment of a stipend, allowance, or other benefits, privileges, or considerations. This is commonly prevailing in the universities and colleges. Number four, when the sexual advances result in an intimidating, hostile, or offensive environment for the student, trainee, or apprentice, any person who directs or induces another to commit any act of sexual harassment as herein defined, or who cooperates in the commission thereof by another, without which it would not have been committed, shall also be held liable under this act. Section 4, duty of the employer or head of the office in a work-related education or training environment to prevent or deter the commission of the acts of sexual harassment and to provide the procedures for the resolution. settlement or prosecution of acts of sexual harassment. Towards this end, the employer or head of office shall, we have here duties that will bound to by our employers. So we have here promulgate appropriate rules and regulations in consultation with the jointly approved by the employees or students or trainees through their duly designated representatives, prescribing the procedure for the investigation or sexual harassment cases and the administrative sanction thereof. So kung may mga sexual advances and there is sexual harassment in the case in the workplace, the employer should immediately take an action for that. Otherwise, they will be liable. No? And administrative sanction shall not be a bar to prosecution in the proper courts for unlawful acts of sexual harassment. Even though there is a administrative sanction such as suspension of the said employees, it will not be a bar. So, pwede pa rin kasuhan yung mga employers or those employees having sexual advances and committing sexual harassment in the workplace to the proper courts for these unlawful acts. The said rules and regulations issued pursuant to this section shall include, among others, guidelines on proper decorum in the workplace and educational or training institutions. Create a committee on decorum and investigation of cases of sexual harassment. So if there is a sexual harassment, there should be a committee to handle sexual harassment cases in the workplace. And they shall conduct meetings, as the case may be, with other officers and employees, teachers, instructors, professors, coaches, trainers, and students or trainees to increase understanding and prevent incidents of sexual harassment. In our case, we orient teachers regarding with the salient features of RA 7877 during our school learning action cell. So it is, we are duty bound. It is our duties and responsibility to inform them, though they have the capacity to search this law, but since we have a busy schedules, we initiate proceedings to orient them. And it shall also conduct the investigation of the alleged cases constituting sexual harassment. In the case of educational or training institution, the committee shall be composed of at least one representative from the administration. The trainers, the teachers, instructors, professors, or coaches, and the students or trainees, as the case may be. Section 5, liability of the employer, head of office, educational, or training institution. The employer or head of office, educational, training institution shall be solidarily liable. Ibig sabihin, if there are damages arising from the acts of sexual harassment, pwedeng maging liable si employer of the acts of the employees who committed the sexual harassment in the workplace. And if the employer or head of office, educational, or training institution is informed of such acts by the offended party, so if they are already informed by the offended party and no immediate action is taken thereon, so they will be liable. The employer or the head of office are liable, solidarily liable for the damage arising from the acts of sexual harassment. And nothing in this act shall preclude the victim of work, education, or training-related sexual harassment from instituting a separate and independent action for damages and other affirmative relief. So if there is a case of a sexual harassment in the workplace, nothing in this act will prevent the victim to have a separate and independent action for damages. So aside from the criminal actions na ifa-file ng ating victim, he or she could file also an action for damages such as payment of moral damages like 100,000 or 200,000 that will compensate that damage done by the person who committed the sexual harassment. And we have here the penalties, though there are a lot of features or provisions of this law, but we will deal only salient features of RA 7877. But if you have, or if you wanted to have an in-depth understanding to this law, you can research it on the internet regarding the RA 7877 and its full text. We have here also Section 7, the penalties. Any person who violates the provision of this act, lahat ng mga provision na na-violate ng ating ng offender shall upon conviction be penalized by imprisonment of not less than 1 month nor more than 6 months. So technically 1 month to 6 months lang of imprisonment, or a fine of not less than 10,000 pesos nor more than 20,000 pesos, or both such fine and imprisonment at the discretion of the court. And any action arising from the violation of the provision of this act shall prescribe in 3 years. So you have to file sexual harassment cases within 3 years. So kung nag-prescribe na, you cannot file. Ibig sabihin, kung after the lapse of 3 years, though you are already informed of the sexual harassment, but after the lapse of 3 years, hindi mo na i-file yung kaso, it will prescribe in 3 years. You cannot file anymore in the proper court except if there is an intervention. But kung alam mo na and then you let 3 years lapse after the offender committed the sexual harassment, then it will bar you to file a case of sexual harassment. And we have to take note that upon conviction, it's only 1 month nor more than 6 months. So 1 month or less than 6 months of imprisonment. Because take note, it is only a sexual harassment. If there is sexual engagement on this part, then you might as well you will file a case of rape. So it's another criminal actions regarding the case. But for the purpose of this discussion, those mentioned provisions lamang ang cover ng ating RA 7877. Other than that, there is appropriate cases na pwedeng i-file ng ating mga victim to the offender. Okay, perhaps that's the end of the topic